We welcome you to this audio series intended to provide information to those eligible for Air Force legal assistance, which include active duty military members, their dependents, and retirees. Our hope with this series, which we are calling The Art of Law at Hill Air Force Base, is that we can convey legal assistance information to you that is readily available, provide information that is responsive to your needs, and to do so in a timely manner. This series is for informational purposes only and is not intended as a substitute for legal advice from an attorney. Today we will be discussing immigration rules and procedures. My name is Brad Bell, and I'm joined by one of my colleagues, Captain Kelsey Knitter, who worked immigration issues first while in law school and afterwards before joining the Air Force JAG Corps. She has continued with that interest, specializing in immigration law as part of her legal assistance practice. We're also pleased to have with us Mr. Fred Molt from the U.S. Citizenship and Immigration Services. Fred has worked in the immigration arena since 1991 and currently serves as a Supervisory Immigration Services Officer in the Salt Lake City office. Welcome, Kelsey and Fred, and thank you for joining the conversation today.
Thank you, Brad. Happy to be here.
And thank you.
This is a very important topic for many of our military members who are serving in the DoD but are not yet citizens. In fact, Fred, you shared with me the other day that from 1918, essentially the end of World War I, to 2022, there have been approximately 780,000 military members who have become U.S. citizens. On average, that represents several thousand a year. Our hope is to provide these individuals with some guidance to help them navigate this important area of the law. So, getting into this topic, Kelsey, from your experience working in this area, what are the biggest issues facing our military members and their families when it comes to this topic?
I would say there's three main issues that we're seeing. The first, naturalization. And when I say naturalization, I know that's a very technical term. What we mean with that is simply somebody getting their citizenship or becoming a United States citizen. The second is getting a green card for family members. And again, green card is the colloquial term, but that actually stands for getting a status that's called lawful permanent residency, or you'll also hear the term LPR. Those are all kind of used simultaneously to mean the same thing, that you are getting some status to be here lawfully. And then the third issue is just, we have, again, the military, we have a lot of family members who are going abroad when somebody PCSs to another country, and how that affects somebody who is in the immigration process.
So very good. You mentioned naturalization. So let's start breaking that down. What are the requirements to actually become a U.S. citizen?
So first and foremost, just need to be 18 years or older, and they need to be a lawful permanent resident, like I said, so somebody who has that green card. And there are varying times that they need to have that green card. So for a spouse, they need to have it for 3 years before they can apply to become a citizen. And for other statuses or other people, it's 5 years.
Okay, so how do you actually apply then to become a U.S. citizen?
You'll apply using a form called N-400. Essentially, you'll submit copies of your green card to show that you have had that green card. You'll have 2 passport-style photos. And essentially, that application will ask you a variety of different types of questions. You'll need to provide information related to your physical addresses, your family members, and then also answering questions related to, how you came into the United States, things like that.
So Fred, you've been working at the United States Citizenship and Immigration Service for many, many years, working these applications and processes. Have you seen any common issues or problems with that application?
On the N-400s, you can file electronically or by paper. Now, on electronics, some people have been having problems with the USCIS system and in uploading all the information. Some of the other problems that they've been having is that they just don't understand all the questions that are required for the N-400. Some of them are very technical. And then the other problems is that if they've been previously arrested, they need to provide court documents.
Okay. So, Kelsey, back to the military unique aspects of this immigration program that you've kind of started here at Hill Air Force Base. What are some unique issues for our service members that they need to be considering?
So I think the first big thing is, as I mentioned before, typically somebody who has a green card needs to wait 3 to 5 years before they can apply to get citizenship. And that's not the same for military members. So depending on, again, if we're in a time of war or kind of what the law at the time says, specifically, you might have to have only 1 year of honorable service, Or I know currently we are having members that actually just are going to basic training, the first step in their military career, and they're actually able to apply for citizenship then. And to do so, they do have to file a different form with the N400. It's the 426, and that is essentially will be signed by their commander, which needs to be an 06 or a colonel or above, and somebody who basically can verify that they are a military member who has served honorably. And I'll also note that the goal of these applications from military members is to be expedited.
Okay. And that's kind of the program that you've set up here at Hill Air Force Base as part of your legal assistance program, is to create this expedited service, correct?
Absolutely, yes. And unfortunately, again, with Fred at the helm, we've been really able to expedite a lot of our applications. And we just recently had one of our military members who, within a month or two of applying, was able to actually become a United States citizen.
That's fantastic. So tell us a little bit about what happens after the application is submitted. What does the member have to be concerned about at that point?
So the big thing there is they will have to take what's called the civics test, and that's something they absolutely need to study for. I think it's sometimes overlooked, but that's where they will answer a number of questions. It'll be 10 questions. They'll need to answer 6 of them correctly about U.S. history and just U.S. government and things of that nature. And that'll be the first stage of their interview process. If they pass that, that'll lead into the actual interview where the USCIS member will ask them interview questions that come from the application to make sure that they answered them correctly. And if there's any concerns about one of them, they will delve into that.
Very good. So Fred, back to you as one who's seen a lot of these applications and maybe done some of these interviews. What kind of issues or concerns have you seen in the past?
One of the most concerns that they have is that they come in the office and they become nervous, and then their brain stops thinking and they can't think of what the answers are. We try to relax them during the interview to calm them down and to get them talking. So one of the most things is for them just to calm down and just think of the studies that they've done. The other part of the problem is that they just understanding the questions itself. If they go through the N400 and read the entire N400 for all the different questions, especially about have they been arrested, have they had military training, all this stuff, if they break the questions down, it's easier for them to go through it.
And I've heard you mention earlier that sometimes it's good just to go out to the building itself, just to familiarize yourself with the location so that you're not intimidated by that part of the process. Is that something that you still recommend?
Yes. We also do have outreaches that we've had different groups come in our building, and we've actually given tours of the offices and the areas. The schools that help the applicants too bring their students through, and just we do mock interviews. So there's always a chance that we could set up a mock interview if they're not sure about what's going on.
Wonderful. So Kelsey, after you pass the test and the interview, what happens next?
So next is going to be your swearing in ceremony, which takes a variety of forms, as Fred just mentioned. Sometimes they happen at schools, sometimes they happen in other locations, but essentially you will go up and you will take an oath to the United States of America and say that, yes, you are willing to take on that oath and become a citizen. And basically after that oath, you will get your citizenship document, you'll turn over your green card, and you will officially be a citizen.
And we actually had one of those ceremonies here at Hill Air Force Base not too long ago, which was kind of fun. And Fred, you were there doing that for us as well. So
it's nice to be able to do the ceremonies in this office. We have 2 different types of ceremonies. We have an administrative ceremony and we have a judicial ceremony. If the service member wishes to change their name, then they'll actually be doing the ceremony at the court itself with an actual judge.
Very good. So let's dive into the issue of green cards just a little bit. You indicated that that's kind of the term that people use, but it actually represents a lawful permanent resident status, right? So who's actually eligible for the green card? And can you just tell us about the different categories?
Absolutely. So again, there's a variety of categories in terms of employment side of things, but I think we'll focus on the family relationship ones because that's what's most relevant to our members that we're seeing in our office. The big one being spouses are eligible to apply. And at the beginning, I mentioned, again, their wait time to apply, once getting that green card, is 3 years, so it's a little bit of a faster process. But children of U.S. citizens can also apply. We have parents are also eligible, as well as siblings, but noting that these different categories all will have different wait times for when people can actually expect to receive those green cards. And it's actually related to something called the Visa Bulletin, which I know Fred can probably speak to a little bit better.
The Visa Bulletin it depends if the person's a lawful permanent resident or if they're an immediate relative. Some of the in the age of the child, if a parent or if the service member is applying for a child that's over 21, then it's considered a preference case, and the wait time is anywhere from 5 years on. If it's a spouse of a lawful permanent resident, then the wait time is pretty much current to like 2 years. And if they're children under 21 to this service member, then we're still talking about a few years wait time.
That's to get the green card.
Correct. So, and I think this is what's confusing to some people is that application, the initial I-130 can be approved, but they'll still have to wait a number of years till they actually can get the green card. And so I know Fred mentioned the spouses and the children, but we also have people asking about parents and siblings, and those wait times are significantly longer, especially for siblings. I think Fred has the numbers in front of him right now. Yes,
for the sibling, or for the say like brothers and sisters of the service member, we're talking about almost up to 15 years for some countries.
So just to be clear here, so if there's a military member, they marry somebody from a different country, that person wants to get the green card. The green card could be approved almost immediately, or do they still have to wait that 2 or 3 year period?
For a service member that's a U.S. citizen, it would be an immediate relative. Okay. Of where that spouse can be approved immediately.
Okay, very good. And let me just throw out another example here. Let's say that a military member marries somebody in a foreign country, and that person wants to bring their in-laws back to the United States. What's the time frame for that?
That would be a little bit longer. That would definitely be the preference cases of where we're talking about the minimum of around 5 years.
5 years. So that would be the in-laws to the military member in that case. Okay, so how do you actually apply for this application? I know there's a series of things that need to be done, paperwork that needs to be filled out. So Kelsey, why don't you explain that just a little bit?
Yeah, absolutely. And this is a very kind of long application process, and so I know certain things get lost on the way. So I'm going to kind of walk through the technical aspects of that. But the first thing is called a 485. That's the adjustment of status application. That's what's going to be filled out by the person who is seeking the green card, essentially. But that needs to be filed in conjunction with an I-130, which is the person who is applying or petitioning for them. So that would be like our U.S. Citizen member or U.S. Military member applying for that family member. Another thing that needs to be included is the 693. It's a medical examination vaccination record. Basically, they'll just have to go to an approved doctor to kind of get that signed off on. The other thing that's sometimes overlooked is the 765. That stands for the employment authorization card, or we call this the work permit colloquially, which is essentially important, especially for our members. It'll provide them, the person who's waiting for their application to be approved, to work legally and also get a social security number. But the other big one that's sometimes forgotten and overlooked and also can cause the most problems is the 864, which is called the affidavit of support. And so that's essentially where the person who is applying for somebody to get a green card is saying they are not going to become what's called a public charge, that they're going to be financially supported while in the country, that they're not going to somehow be kind of a drain on our resources. So to kind of, in conjunction with that, it needs to be filed with a lot of financial documents. So they need to include tax records, financial statements, proof of employment, things like that. And it's essentially to show that they are 125% above the poverty line. What I will note is that it's only 100% for our military members, so they do get that little bit of a benefit there. And also, if for some reason they're not able to kind of meet that threshold, there's also what we can call a joint sponsor, which is you have a second person who signs on and says, I will be financially responsible for this person because, that one person alone couldn't do it.
So Fred, maybe a question back to you. When Kelsey is mentioning the poverty line, is that like a national standard or is it a state-by-state standard? Because some states' cost of living is a little bit more than others.
It goes by the 48 contiguous states, and Alaska and Hawaii would be a little bit more. But we're talking about, for 2023, the poverty guidelines for contiguous states would be 19,720. And the normal, even the E1 private would be making about 23,000, so they would qualify.
They would qualify. Very good.
And kind of the last thing, semi-related to that as part of the application is there's a filing fee associated with it. So the application itself will cost somewhere upwards of over $1,000 typically. And so not only are you proving you have this affidavit of support, but you are required to file a filing fee. However, I know that there are certain situations where there are fee waivers that can be granted, and I'll maybe let Fred describe a little bit that distinction between having the affidavit of support while also still being eligible to apply for a fee waiver on these applications.
For some members that have high medical bills or they have other issues that they could not, they're having problems with money, that we do offer fee waivers and reduction fees for any individual filing with the USCIS. It could be that they just need to show that there is a financial need, and it does not affect their affidavit of support.
Wonderful. So we've talked a little bit about green cards for spouses, children, parents, even in-laws. What about fiancés? We have airmen overseas, and they fall in love and want to get married. And so how do they work these immigration paper requirements for a fiancé?
Yeah, absolutely. And this, again, a very common one I think that we're seeing, especially in the military, like you said, because our members are all over the world. But it's basically what they would need to use is called a fiancé visa, or it's a K-1 visa. So to do that, you file an I-29F form. And it's essentially, you need to be able to establish that the validity of that relationship. So saying, hey, this is a real person that I'm interested in. And to do that, you'll submit a number of pieces of documentation regarding that, meaning photos, receipts and stubs from like dates and things like that, plane tickets to visit each other, things of that nature. But essentially the fiancé visa, then what it'll do is allow that person who's outside of the country, who's the fiancé, to come to the country specifically for the purpose of getting married. So they'll get basically 90 days in which they can actually, that they need to actually get married in that window.
And how long does it normally take to be able to accomplish that?
So I think we're looking at about a year typically for all of that to happen. I know we've had some members who've tried to expedite that, and they've done that through having a commander write a letter kind of explaining the urgency of having this application prioritized. But and again, I will note that it's not completely on USCIS. This application goes through USCIS first, but it is also largely dependent on the consulate in the country where that person is located. So once it's kind of passed through our side of it, that person then will need to go to the consulate in their own country, do an interview, and that is what can often take a lot longer and kind of is out of our control.
And that has to be the consulate of where they're living at the time.
Correct.
Right. Okay. Very good. So, Fred, have you experienced any kind of issues or pitfalls with regard to the fiancé?
Well, with the fiancé visas, the individual needs to have visit the fiancé within the last couple of years. Then they need to prove that there's some type of relationship. But the main thing is that the individual needs to be free to marry. And if he's ever had any previous marriages, then he needs to provide divorce papers and all the information about that.
Very good. So when we're talking about these processes, lots and lots of paperwork and lots of requests for information or evidence, can you tell us a little bit about some of the pitfalls that you've seen with regard to your request for evidence, and maybe they don't have all the information they need at the time? What is your way of handling that?
The request for evidence, they need to read the requests and make sure that they provide all the information that we request. Like with court documents, we're asking for court documents, we're asking for minutes, we're asking for, if they've done an expungement, they need to give us the entire paperwork on how that, the original documents and the reasons for the expungement. If there's a reduction in the crime as an expunge or as an Section 402, which we say which reduces the crime itself, then they need to provide all the information about why this was. And one of the things is that just this a Section 402 reduction does not mean it will be for immigration purposes.
And you're talking about for an individual who may have been convicted of a crime here, and it was in the court process expunged the record, and you're seeking all that information so you know exactly what happened and the details of that.
True, because there are some crimes that are considered crime against moral turpitude, and then we have what's called an aggravated felony. An aggravated felony has to be proven that it's not a permanent bar to adjustment of status or to citizenship.
Very good.
And I'll just note too that the RFEs that I've seen, and sorry, I say RFE, that means request for evidence, come back are often related to that affidavit of support that I mentioned, because again, that requires a lot of documentation. So again, as Fred was saying, it's really important to read very closely specifically what they're asking for. And even when applying, there's a very detailed instruction for each application. So they'll have the application itself, but they'll have instructions for each kind of question, and it'll go through, the documentation that's needed if you answer yes to a particular question. So I think sometimes that's overlooked, and that'll trigger this RFE to get sent out.
And what happens if they don't submit all the correct documents? What consequences?
Okay, so what happens is if they don't submit the request for assistance timely, then their case can be denied. So that's one of the things that we want the service member to do, is to make sure that, one, if there's any changes of address, that they provide the changes of address. They make sure that USCIS has their latest, because if we mail the request for assistance or request for evidence to the wrong address, then they're not going to receive it properly. So maintaining the proper address, moving is not an issue, but updating their address is the issue.
And I will add to that, again, so he says if you're not doing this properly, you don't respond to it properly, your application is denied. And that's a big deal because, like I said, there's a filing fee associated with this application that's not necessarily very cheap for some people. So if we're talking $1,200, they're going to have to fill out the entire application again, but they're also going to have to pay that fee again. So that's why it's so important when they get that RFE to make sure that they're submitting everything on time and everything that's being asked for.
If for some reason that they could not submit in time and the application is denied, there is still one avenue that they can file within 30 days, which is called an appeal, which is a 290B. The 290B is saying that please reopen my application, or please look, and then they need to put the evidence that we requested or the reason that we denied it to start off with.
So the key to all this is make sure you have all the information. Better if you get it up front and the first time around, but if a request for evidence comes in, please take a look at it and make sure you provide it.
Absolutely. And I'll note, again, I think it's helpful to come through the legal office if you can, or even hiring another attorney who can review those forms for you, because, again, they are extensive for somebody who's never done it before. You might overlook something that's going to trigger that RFE, just delay things. So if you have the resources to reach out and get somebody who can review it for you, I think it's a really great idea.
And also, too, USCIS on the website provides all the information that they would need to provide with the form itself. Every form has got instructions. So they can also read the instructions onto it to see what's the different evidence that they need to provide.
And so all these forms, like you said, are on the website at the USCIS.
Correct.
Very good. Very good. So, Kelsey, let's talk a little bit about military-specific issues. What about families who are PCSing or moving abroad? They've got their green card here in the United States, but now all of a sudden they have orders to, let's say, Japan or Germany. Can a green card holder, a dependent, leave the United States?
Yes, they can. And actually, that's kind of almost two different questions a little bit. So we need to distinguish who's the green card holder. So spouses, for instance, they can actually expedite their naturalization application. And there's a way of doing that. But if we're just talking about, I think in the situations that we've been seeing it more frequently are parents. Somebody's taking care of a parent, elderly parent who's their dependent in the military, but they now got PCS orders to go somewhere abroad. And so there's kind of two different things they can do. The first is we would encourage that they apply for a re-entry permit. And that is, again, on the USCIS website, it has that form. And it basically will allow them to leave for up to 2 years. And the reason that is important, it means they can come and go from the United States without an issue. But it also will keep their clock for their residency requirement running. So as I mentioned at the beginning, they have to potentially stay for 3 to 5 years as a green card holder with that residency before they can apply for citizenship. If they leave the country, that clock will eventually stop unless they have that reentry permit. And another option, again, and especially if they are going to stay over 2 years and they don't want to apply for another reentry permit, there's something called the SB1 visa, which is something that the member can apply for at the consulate in the country where they are bringing that green card holder. and it will, again, allow them to come back into the country without issue.
And so just to be clear, if it's the spouse of the military member, the spouse is the green card holder, they can go without having the reentry requirement, or do they still need one as well?
They might still need one. It's just their applications in particular can get expedited. They have kind of a priority as a spouse.
And how long does it take for someone who isn't a spouse, let's say it's the parents that you're taking care of, how long does it take to actually put in that application before it's approved?
The application to 131, the application can take anywhere from 3 to 6 months.
Okay.
And as long as they apply for it while they're in the United States, then they can have it mailed to them or have it mailed to the consulate and pick it up at the consulate office.
What about family members that entered the United States without status? Are they still eligible to adjust that status?
Yes, they are. And just to be clear, when we say without status, that basically means somebody that came across the border and they weren't inspected or they didn't get any type of documents that they could be here. And so fortunately for our military members, there is something called parole in place. And it's essentially this means where if you had a family member who came without status and they're here without status, you can apply for parole in place and it'll essentially adjust their status to being lawful so that they can apply for that green card in the interim. And again, I think that's, it's for all immediate family members. So for those that maybe have a parent or something that came here without status, this is a means that they can help them start getting that green card, even if they didn't come in with a visa or anything like that.
Very good. So the military member who has the green card, as well as any immediate family member, the parole in place concept applies if
Absolutely.
they initially came into the country when they didn't have authorization to do so.
Right. And actually, I should mention here, too, in the situations where we had somebody who came lawfully, so they came on a visa. So, for instance, we have a student visa or something like that, and then they overstayed and they didn't leave when they were supposed to. That's a slightly different situation. But again, for immediate family members in that situation, if they leave the country, they're going to have a bar because they've overstayed. However, if they don't leave, there's kind of an exception. So for instance, a spouse, somebody who got married while maybe overstaying that visa, they can still apply for that green card. They just have to note it on the application that they overstayed, provide that documentation that they came here lawfully, and they will still be able to adjust that status.
Yeah, in fact, we just had that question recently here in our office where somebody came legally, overstayed by several months their opportunity to be here, and then ended up marrying a military member. Mm-hmm. And so the question was, does this person need to go back to the country of origin, or can they adjust their status here? And you're telling us here that they could just have it adjusted.
Yes. Again, with the warning that don't leave the country once you've overstayed, because that's when some of those bars, depending on how long you've overstayed, will start to kick in. And if you try and come back, those will apply.
I see. Very good. All right. So what are some of the biggest concerns or bars to status? For example, what might disqualify somebody from getting their green card?
So I think the first one, and Fred already touched on it a little bit, is these crimes of moral turpitude, how USCIS refers to them. So we're talking about felonies and certain maybe aggravated felonies of certain serious offenses. And I maybe can turn that over to Fred a little bit to speak a little more directly onto what they're looking for specifically when considering crimes of moral turpitude.
Right. We're talking sometimes simple burglaries, shoplifting. These are, although the sentence might not be extensive, that the crime itself is considered CIMTs. And with 2 CIMTs, then they could require a waiver. And if they do have serious crimes, they could be a permanent bar from gaining permanent residence.
But I think the big takeaway, though, is it's those bigger crimes. So some of the lower level stuff, more like petty crimes and things like that, shoplifting, probably are not going to trigger that bar or even need the waiver. It's more important to be upfront about that. So I think the biggest thing that we're trying to warn people is don't try and lie or hide that you might have a criminal history, because it's when they find out that there's actually going to be much more serious consequences than maybe that small shoplifting thing in the first place.
For the first crime, for the first serious crimes such as shoplifting, there's what's called the first offenders, in which we waive the first CIMT.
And the CMIT, just to be clear, stands for?
crime against moral turpitude.
Very good. Very good.
Yeah, and I think the last concern people have is for people who've been previously deported. That is also kind of something that is going to trigger maybe some additional things that need to happen. Again, I'll let Fred speak to it a little bit more, but it's not a complete bar to you being able to get some type of status. But there are going to be more hurdles to go through if, again, you've previously been in the United States unlawfully, gotten caught and been deported, and then you came back. Some of those problems will come up.
Yes, for the people that have been previously deported, if they go to the consulate and apply for a waiver or verify the requirements for them to stay out a certain amount of time, then there are avenues for them to come back in legally.
So just to be clear, Fred, the USCIS has access to all criminal databases, right? So you will find out what kind of criminal activities individuals may have been engaged in, correct?
Yes, we do have people that have also used fake documents, and then those people were fingerprinted at the before deported. So those fingerprints, even though that they've used somebody else's name, will tie them into a current status.
Very good. I know that we've already covered a lot of these tips for these immigration documents and such, but it sounds to me like one of the most important things is to be familiar with the USCIS website, that all the updated forms are there with all the instructions, correct?
Correct.
Make sure to be regularly updating your USCIS with your new address so the information can get to you in a timely manner. Be honest, above all, and then to reach out to JA if you have questions, or reach out to our office. So let me just thank you, Kelsey and Fred. This information has been extremely helpful, particularly for a lot of our military members who are not U.S. citizens yet. And for those who still have some remaining questions after this podcast, if you want to call our legal assistance office at 777-6626, we'll be able to set you up with a legal assistance appointment. And there's also a military hotline for this immigration paperwork, and that's at 877-247-4645. Any closing comments or things that you'd like to mention before we close?
For one of the, we do have a contact center with USCIS, and you can always call the contact center, and if there's a serious issue, you can always come to the USCIS office and make what's called an InfoPass appointment. And then we provide assistance, questions, and advanced paroles. We provide all kinds of information if needed. Our contact center will also provide any information that's needed to help you with your application.
Very good.
And the last thing I will add is just a little bit of plug for our immigration program that's been started here at Hill, and in part due to our relationship with USCIS and Fred in particular. But we've seen a lot of success in expediting our military members' applications and their family members' applications. So I know we just very recently had a green card application from a spouse, and normally that can take about a year on average, a little more sometimes depending on things. And with the help of USCIS and Fred in particular, it was completed within 1 month. We have a member who's receiving their green card after a month. So we're really excited to have that, and that's why, again, we want to encourage people to come through our office because we can, even if they've already submitted the application, we can maybe potentially help expedite it or figure out why it might be delayed or stuck.
Well, once again, thank you, Kelsey and Fred, and thank you to all those who've been listening to this podcast, and we wish you a wonderful Air Force Day.